There we go. Good morning, Bruno.
Hey Nick, how are you?
Doing well. And you?
Good, good.
Good. So, another episode of PLA. We're going to start with you, Bruno. And over the last couple of weeks, we've been looking at different structures and companies, etc. And last week, we dealt a little bit with the distinction between shareholders and directors of a particular company and what their different functions are. And what I would like you to just touch on today is obviously we've distinguished these two entities, but really what governs the way these two distinct entities are supposed to behave and what they're supposed to do in relation to a company.
So how does a company really function? We spoke about shareholders and who owns the shares in the company. We spoke about directors and who actually operates the company. But where are the rules? How do you determine what they are entitled to do, what they aren't entitled to do? This is particularly important when there's multiple shareholders, and multiple shareholders need to be able to agree on how the business is supposed to function, when there's supposed to be exits, what is supposed to be acquired, what the nature of the business is, right? So we use memorandums of incorporation, or otherwise known as MOIs, and we use shareholder agreements. Now, the Memorandum of Incorporation is a public document. This sits with the CIPC and is available to anyone that wants to download the MOI. Why that is? It's because everyone should be familiar with the company's MOI if they're contracting or have a relationship with that company. They should know whether the directors are entitled to make certain decisions or not. So it's basically a public disclosure document that you should know as an individual before entering into any contract with a particular company, because later it's very difficult to hide away and say, but the director signed, when the MOI specifically says that one director cannot sign an agreement of any specific contract. So the MOI actually sets the rules for how the company is governed internally. It sets the rules for when directors should meet. It sets the rules for how the meeting should look like, what the notice of the meeting is, how many directors should be at the meeting before a decision can be made. Are there any specific decisions that fall outside the scope of directors? It speaks about shareholders. When should shareholders be meeting? What decisions should they be making? What constitutes an ordinary resolution? What constitutes a special resolution? All these things are contained in the MOI. It's a public document and speaks about the company and what the company can do and what these role players or officials or officers in the company need to do in order for the particular company to move forward and make a decision, right? So think about it as an operating manual that says everything about the company, everything important about the company the public should know about. Then internally, there's something called a shareholders agreement. Now, a shareholders agreement is usually and supposed to be utilized to govern the relationship between shareholders, right? That is the most important function. Now, obviously, there's certain things in the shareholders agreement that sometimes overlap with the MOI. So if you are having one prepared for your business, make sure that you know where it belongs. Typically, the MOI is the best place to put things because it makes it a rule and it cannot be changed unless very specific provisions are followed and you go to the CIPC and you change the MOI. Whereas a shareholders agreement, by its very nature, is an agreement and it's only binding on the people that actually sign it, as opposed to an MOI that's binding on all those officers and role players in the company. So a shareholders agreement normally governs what happens to the shares if somebody, for example, is going to pass away or is declared insolvent, or, for example, commits an act of fraud, and you want to be able to force the transfer of those shares into the hands of somebody else. Now, these are all very common provisions in the shareholders agreement. And I could sit for hours discussing them, but we don't have the time to do that. So very important ones are that go into the shareholders agreement are specifically the ones that deal with unforeseen or unknown circumstances that may result in a shift of shareholder. And what do I mean by that? if I own shares in a company and I pass away, what happens to those shares? Well, usually they would go to my beneficiaries, my heirs, right? So you may very well find tomorrow my wife is a shareholder of your company. And this changes the dynamic, especially in small businesses, where you can't just have any person that knows nothing about the business trying to call shots because certain decisions fall in the hands of shareholders. Also, another problem, if I pass away today, it takes so long in South Africa for an executive to be appointed to administer an estate that you're going to find that business continuity may actually completely cease, given that if shareholders are responsible to make decisions and not directors like it's supposed to be, a decision cannot be made until an executive is actually appointed. So that's why I always tell people, make sure directors do carry the bulk of the responsibility when running the company, and make sure that's in your MO1. Limit the amount of decision-making power you put on the directors, and certainly limit how much of it requires unanimous voting. Because it sounds like a good idea at the beginning where everyone can say yes. Unfortunately, we don't think of situations where there's fights and when there's death, right? Or insolvency. So your shareholders agreement normally governs what happens in these circumstances, especially to the shares themselves. Now, if somebody does pass away, you could, for example, put a little trigger clause that requires that their shares be moved over to another shareholder. And sometimes we actually include insurance policies into these agreements or alongside these agreements, so that upon somebody passing away, a life insurance policy actually kicks in and is utilized by the one shareholder or by the company to buy back the shares of the other shareholder. And the upside there, for example, going back to my previous analogy, if my wife was going to step in to the shoes of a shareholder, now instead she simply receives money for the shares, and the shares go back or go into another shareholder's hands. So those are the type of things that you definitely need to put in there. Another example is a split commits clause. A lot of relationships go bad, and you want to make sure that if somebody's bad for the business, even a shareholder, if they're bad for the business, that there is a way of getting them out. And we normally do this through little tests where we have clauses where if one shareholder fails a certain test or does something they're not supposed to do, the shares can actually be acquired back. Same thing with insolvency. Now, other things that we sometimes look at in the shareholders agreement, and this is important because people never think about it, is exits. So it's not just about the sale of shares, it's also about exits. Now, if you as a shareholder want to exit a business, can you just go and sell your shares to anyone? No. Very often, these shareholders agreements should provide for you having to first make this offer for the sale of your shares to an existing shareholder and not a new person. Again, to keep the shareholders pot close, people know each other, at least that person then has the opportunity of buying the shares back. That's exit. Another type of exit is also the business strategy. A lot of property investors, for example, go in and buy a property, and they're very excited about the prospect of the property earning cash flow. What happens when one shareholder says that they want to sell because it's not a good asset anymore, and the other one disagrees and wants to keep that asset? You need to think ahead, especially with such big assets as properties, but businesses in general. When does a person have to make a decision to exit or to stop doing something that's not working anymore? Those are two very, very, very important rules or governance principles that I always tell people they have to do. There's a whole bunch of other ones, and they're nice to have, and some of them really you should, depending on your business. But if you don't have these, you're definitely asking for trouble.
Absolutely. Thank you for that, Bruno.